Judge, we're waiting on paperwork for one of mine, and I have a couple things to talk with. So at this point, if I may have some time to speak to my clients and wait on the paperwork, it will be ready here shortly. So
Robin Mangum. This is cause number CR 26-59. All right, Mr. Mangum is charged with first degree aggravated sexual assault of a child, therefore arraignment. Mr. Richard Schmidt is appointed as counsel. Mr. Schmidt, you ready to proceed?
Yes, sir. See, it's over. Wait, reading.
All right, court enters Mr. Mangum's plea of not guilty into the record. Finds that he's waived the formal requirements of arraignment. Court sets Mr. Mangum then for pre-trial hearing. Have you already received discovery in this case, Mr. Schmidt?
Yes.
Are you still in the process of reviewing some?
Yes, sir.
You want me to set August 25th?
Yes, sir.
All right, court sets Mr. Mangum then to pre-trial August 25th. At 1:30. Earl Eugene Mosley, CR 25236. All right, Mr. Mosley is here today on the state's motion to revoke the burglary of habitation. But
Recently forwarded to, or appointed Mr. Mosley.
sorry, I couldn't.
So it was just recently appointed, yesterday. So that's for, saying when the next event.
All right, court sets Mr. Mosley then for contested hearing on 8/27. Who's that other line? There. Line next to that, right? What else?
Yes, sir.
It's good back at the workplace.
Can you hear me now?
It'll pick you up.
Can you hear me? John Allen?
Ron Michael Allen, CR 24253. All right, Mr. Allen's here on state's motion to revoke unlawful possession of firearm by felon.
Same announcement, Judge. In addition, I think Mr. Allen has some additional charges that we need to discuss with the state. I think they're unindicted, but we'd ask for that August 25th date.
All right, court sets Mr. Allen for August 25th. At 1:30.
Donald Ellis?
Donald Allen Ellis, CR 2483. All right, Mr. Ellis is here on state's motion to revoke for arson.
Same announcement, Judge. Mr. Ellis was just recently arrested on the state's motion. Ask for that August 25th date.
All right, court sets Mr. Ellis hearing on the motion to adjudicate August 25th. 1:30.
You should have a plea ready for Trevor Blackman.
Yes, Mr. Blackman. Cause number CR 23200, state versus Trevor Troyce Blackman. All right, Mr. Blackman, if you'll raise your hand, I'm going to place you on the oath. Do you swear that the testimony you give works be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, Regan. All right, Mr. Blackman, you were before the court previously on June 13th of 2024. You pled guilty to theft of property greater than $30,000, but less than $150,000, a third-degree felony. Court heard the evidence and followed a plea agreement that day, wherein the court found that there was enough evidence to convict you. But the court deferred a finding of guilt and placed you on community supervision for a period of 10 years. And also, during that period of community supervision, the state has filed an amended motion to adjudicate and revoke. And in that motion, they have alleged 13 separate allegations of violations. Have you had enough time to review those allegations with your attorney, Mr. Smith?
Yes, sir.
Say yes or no?
Yes, sir.
Yeah, okay. And are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Do you understand everything that you've read and signed as part of your plea agreement today?
Yes, sir.
I see that your plea agreement is upon you pleading guilty, the state's recommending that the court adjudicate your guilt, convict you of that original offense of theft of property greater than $30,000, less than $150,000. Your community supervision would be revoked and you would be sentenced to prison for a period of 4 years. And you'd be ordered to pay anything that you have left on your restitution, court costs, and reimbursement fees. And you would also receive some credit time towards your sentence for the time that you've been in jail. How much time is that, Mr. Smith?
1 second, Judge. We have 103 days, Judge.
103.
Yes, sir.
All right. And so, Mr. Blackman, that's how much credit you received toward your sentence. Is that your understanding of the plea agreement and what you're asking the court to approve?
Yes, sir.
All right. And Mr. Schmidt, do you believe Mr. Blackman to be competent in entering into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily?
Yes, sir. On all counts.
All right. Does he waive the formal reading of the state's motion?
We waive.
Does he intend to plead true to all counts?
Yes, sir.
All right, Mr. Blackman, how do you plead to counts 1 through 13 as alleged in the motion? Are those counts true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true to any of these counts today?
No, sir.
All right, court will accept the defendant's plea of true to each count as alleged in the state's motion. Court also admits the defendant's waiver of rights and plea of truth into evidence. Anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, then based on the evidence, the court finds that the defendant has violated the terms and conditions of his community supervision. The court finds counts 1 through 13 to be true. On the basis of that finding, the court follows the plea agreement today. The court adjudicates the guilt of the defendant, convicts him of the third-degree felony offense of theft of property greater than $30,000, less than $150,000. Furthermore, the court revokes its community supervision, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and awards him 103 days credit towards his sentence. Mr. Blackman, once you're released from prison, then you need to appear at the courthouse if you've not paid off all of the fines, restitution, and those things that you owe. Otherwise, your failure to do so could result in the court issuing a warrant for your arrest. Despite popular belief, just because you go to prison doesn't discharge what you owe.
Yes, sir.
So don't think whenever you're being processed out that all of that has gone away. This is still the judgment. Okay.
Yes, sir.
All right. I'm gonna have you step over to be fingerprinted. You're hereby remanded to the custody of the sheriff's office so they can carry out the terms and conditions of the sentence.
Yes, sir. Thank you.
All right. You ready, Mr. Watson?
Yes, sir.
All right. Somebody get Mr. Watson, please.
We've already dispatched it. Yes, sir.
Court call CR 22-198, State of Texas versus First Storm Watson. He's in the hallway.
They went to get him and should be coming in.
All right, Mr. Watson, if you will raise your right hand on the place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you come forward. All right, Mr. Watson, you appeared before this court on May 9th of 2023, wherein you pled guilty to the second-degree felony offense of accident involving death. The court considered the evidence that day and also your plea agreement. The court followed the plea agreement and placed you on the deferred adjudication for a period of 8 years. And the court also ordered you to pay a $2,500 fine. It was during that period of community supervision that the state filed its motion to adjudicate. And in that motion, they have alleged 4 separate allegations of violations. Have you had enough time to read over that motion with your attorney? Mr. Schmidt? Yes, sir. And do you have any questions about anything that you have read, signed as part of your plea agreement? No, sir. Are you pleased with Mr. Schmidt as your attorney? Absolutely. All right, and I see, Mr. Watson, that the plea agreement today is upon your plea of true to the counts alleged, the state's recommending that the court consider your violations, adjudicate your guilt, revoke your community supervision, and assess your punishment at 8 years confinement in prison. Also ordering you to pay the balance of your unpaid fines, court costs, and reimbursement fees. You would receive credit towards your sentence for time that you have spent in jail. What is the credit time, Mr. Schmidt? So it's 2. Yes.
Four days.
4
4 days, Judge.
4 days.
We concur.
All right, thank you, Ms. Curry. All right, and so you would receive 4 days credit towards your sentence for time that you've already spent in jail on this case. Mr. Watson, is that your understanding of the plea agreement? Yes, sir. That's what you're asking the court to approve? Yes, sir. All right, Mr. Schmidt, do you believe Mr. Watson to be competent to enter into this agreement? And if so, he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
Yes, sir.
And does he waive the formal reading of the state's motion?
We waive.
He intends to plead true to all counts?
Yes, sir.
All right, Mr. Watson, court would ask you at this time, how do you plead to counts 1 through 4? Are those counts alleged true or not true? True. And has anyone threatened, forced, or pressured you to plead true to any of the counts in the motion? No, sir. All right, court does accept the defendant's plea of true to each count as alleged. And the court admits the defendant's waiver of rights completely into evidence. Anything further from the state?
No, Your Honor.
Further from the defense?
No, sir.
Based on the evidence before the court finds that the defendant has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. Court hereby adjudicates the guilt of the defendant, convicts him of second-degree felony accident involving death, revokes his community supervision, assesses punishment at 8 years confinement, the Texas Department of Criminal Justice. Furthermore, the court orders him to pay the balance of his financial obligations, including fines, court costs, and reimbursement fees, and awards him 4 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Watson, you hereby remain to the custody of the sheriff, so I can carry out the terms and conditions of the sentence. Once you are released, if you've not paid off your fines and fees, you need to report back here to the courthouse and pay those. And if you're unable to pay those, then enter into some kind of otherwise, you could be arrested for your failure to comply with the judgment. Do you understand? Yes, sir. All right, I'm gonna have you go with Sergeant Martinez. We're gonna take you into custody and take your.
Yes, it did. Let's just change it up. Conditions, yours, please.
Nice.
Oh,
Send them through.
Dwight, are you ready?
Hi, yeah,
All right. Sure. Gustavo Miguel Castillo. Come on up. Yes. All right, Mr. Castillo, the court's gonna reset your hearing to August 13th at the request of council. So we'll see you back on that day at 1:30.
Oh, yeah.
Take us away. All right, Mr. Manning, who are you ready on?
Judge, if we'd like to start with, Mr. Baker.
Michael Glenn Baker, CR 26-7. Also CR 2641. And Mr. Baker's here today on docket call for assault, second degree, and also pretrial for sexual abuse of a child. Any announcements on pretrial?
Yes, Judge, we had, we sent him from, was it last week, test, it's the jail overall discovery. I was unable to do so, it's, press was set on. The for retrial, CR 2641, and it's done on 6 or so.
All right, Mr. Baker, court sets you again for August 13th. Both cases. Next.
Judge, next we have Mr. Price.
Bryce Andrew Brewer, CR 24-3. All right, Mr. Brewer, if you will raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, all right, Mr. Brewer, you appeared before the court previously on July 9th of 2024. You pled guilty to theft of property, a third-degree felony. The court heard the evidence, followed a plea agreement, placed you on deferred community supervision for a period of 10 years. And during that period of supervision, the state has filed their amended motion to adjudicate and revoke on the basis of 14 counts of violations. We had enough time to review that motion with your attorney, Mr. Manning.
Yes, sir.
Do you understand everything that you've read and signed today that's part of your plea agreement?
Yes, sir.
And are you pleased with Mr. Manning as your attorney?
Sir.
Mr. Manning, do you believe your client to be competent to enter into this agreement? And if so, he's doing it intentionally, knowingly, voluntarily. Does he waive the formal reading of the motion?
He does, Judge, and just, reach much further, the state had to reach to a big there, which is, a student offense. He will be pleading true to all other counts besides the others.
Very well. All right, Mr. Brewer, I see upon your plea of true to counts 1 through 12, the agreement appears to be that the court would adjudicate your guilt. That means convict you of the offense of theft of property greater than $30,000, less than $150,000, which is what you were on probation for. That your community supervision would be revoked, and then you would be sentenced to 4 years in prison. In addition, you would be ordered to pay the remainder of your restitution and court costs and reimbursement fees. Then you would receive credit towards your sentence for the number of days that you have spent in jail, which is what, Mr.
52 days, Judge.
52 days credit towards your sentence. Is that your understanding of the agreement, Mr. Brewer, and what you're asking the court to approve?
Yes, sir.
Right. All right, then, Mr. Brewer, at this time, I would ask you, how do you plead to counts 1 through 12? Those counts true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true?
No, sir.
All right, the court does accept the defendant's plea of true to each count as alleged 1 through 12. But the court notes and finds for the record that state has abandoned count 13. Furthermore, the court does admit into evidence the defendant's waiver of rights and pleading true. Anything further from the state? No, Your Honor. Anything further from the defense? Absolutely. All right, and then based on the evidence before the court finds that the defendant has violated the terms and conditions of his community supervision. Court finds counts 1 through 12 to be true. Therefore, the court does follow the plea agreement today. The court adjudicates the guilt of Bryce Andrew Brewer, convicts him of theft of property greater than $30,000, less than $150,000, or revokes his community supervision, assesses punishment at 4 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of restitution, court costs, and reimbursement fees. And the court awards 52 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Brewer, when you are released from TDC, if you've not paid off the restitution, court costs, and fees, then it's important that you make arrangements here at the courthouse to do so. Failure to do that could result in you being rearrested for failure to comply with the court order. You understand?
Yes, sir.
All right, Mr. Brewer, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you go over to be fingerprinted with Sergeant Martinez. Who do you want to?
Judge next, we have Mr. Charles Hurst.
Charles Harrison the second, CR 24-72. Harrison, just right behind that, go across is fine. You're right there. If come across. All right, Mr. Harrison is here today on pretrial.
Yes, Judge. Previously, Mr. Harris and I had reviewed the documents he's provided in support of this case, and we have not had an opportunity to review the state's discovery. Out of that, I'd ask for one additional pretrial to review that as well as discuss it off those meetings today and potential resolution of part on this case.
Any objection from the state for an additional pretrial?
No, Your Honor.
All right, court sets Mr. Harrison in for pretrial August 13th.
And Judge, one final question on Mr. Harrison. In looking at his case, we were unable to locate what bond amount is set beyond public access for sheriff's office. And I was unable to pull that. The clerk side, is it possible?
Let me check. All right, Mr. Mayor, I don't see that one has been set, I think in December 17th, 2024. Mr. Harrison's bonds company filed a affidavit of surrender. Original bond amount was 100,000, that was granted by the court, the surrender was for the warrant to issue. I do not see that another bail has been set, so I'll set that today at 250,000.
Yes, Reggie.
All right, court sets Mr. Harrison August 13th.
Thank you.
You're welcome. Who would you like?
Good, next, Alejandro Bolton.
Ms. Moda, CR 22-113. Ms. Alejandra Rita Moda is here on the state's motion to adjudicate or revoke. Whoops.
Judge, we made requests, we lapse safety, state, information part of non-use that. They provided a resolution of 2 years to CJ, which my client wishes to accept. At our next docket session.
You want that on Tuesday, the 25th, week after next, or the 27th?
Just
27th is a Thursday, 25th is Tuesday.
did you say that?
25th is a Tuesday, 27th is the evidentiary docket, it's Thursday.
August.
August. Oh, I'm sorry. No, that's not right. So we're gonna be sitting over a month.
Judge, I know we don't normally do this, but it would be, it works, the court entertained soon the elements, so log in through up for their stuff.
I don't have a problem with that, I think it's gonna be about availability. Is something that we could do tomorrow? That's too soon.
How are you available?
Looks like I had a bench trial that has been removed tomorrow morning, so we can do it anytime between 9 and 10:30.
Yes, Judge.
You wanna do that?
It's a statement, or the paperwork then.
Yeah,
fine.
it's fine. You wanna say 10 o'clock?
Yes.
Or is earlier better? 10. Okay. All right, Ms. Moto, and do we wanna do it Zoom or do you want me to just have it brought up
Whatever's easier for the court, I think be the jail anyways.
tomorrow?
Yes,
All right,
Judge.
then we'll just do, as long as the jail can accommodate us, sure. Jail says they're good, okay. All right, so we'll just plan on seeing you on Zoom tomorrow at 10 o'clock, okay?
Okay, thank you.
You're welcome. Manny, is that all your kids?
Judge, actually, I was appointed to Mr. Ellis. To represent my motion to adjudicate or revoke.
Okay. Mix up on it. You have an appointment, Mr. Ellis? Donald Ellis. Donald, I,
On, they are on the card.
you did, yeah. At least, has one.
on Tuesday at
Did it have your name on it or did I picture? Is that the one? So what, he requested, set it on when the. Tell you what, let's do this, let's change that. Set. Set LS August 13th.
And Judge, I just think we the notes, Carl.
Okay, yeah, let him know that, Mr. Abraham and I talked about that. That he would be receiving you because he had a description of it.
And Judge, I do know that my name was provided in. Order.
Thank you, yeah, I'm glad you pointed that out. So what we'll do is let's set it August 13th. And then we'll go from
I believe that you know it.
yes. Yes, I'll follow. Mr. Gammons. Gammons here, come on up. This is cause number CR 2636, State versus Roger Dale Gammons. All right, Mr. Gammons, the board had previously appointed Mr. Schmidt to represent you. Mr. Schmidt indicated to the board that he had a conflict between you and co-defendant, so he's not gonna be able to represent either one of you. So, the board is appointing, Justin King to represent you. He cannot be here today, so I'm gonna set you for, August 13th. King will be in contact with you once he gets, back to his office. Okay. This is cause number CR 26-16, 2026-20. State of Texas versus Clay Press Walsh. I don't think I have the paperwork yet.
Stated about 1.5 minutes ago.
That was this way. All right, Mr. Walsh, if you'll go ahead and raise your hand, I'm gonna place you on the oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you go?
Yes, sir.
All right, good Lord. Your name is Clay Press Walsh, is that correct?
Yes.
Mr. Walsh, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In both of these cases, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
You understand everything that you have read and signed as part of your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Mr. Walsh to be competent to enter into a plea agreement today? And so that he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
Yes, sir, I do.
All right, Mr. Walsh, you are charged by indictment. With a third-degree felony offense of assault of a family or household member by impeding breath or circulation. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in prison and a possible fine not to exceed $10,000. I see that there's a plea agreement in the case. Find you pleading guilty to the offense. The state is recommending that the court consider the evidence, not make a finding of guilt today. Place you on deferred community supervision for a period of 8 years. Assess a $2,500 fine. No contact with the victim in the case as a condition of your community supervision. And also, the state would dispose of a filed misdemeanor clause of 2026-20, which is a violation of a bond or protective order. Mr. Walsh, is that your understanding of the plea agreement?
Yes, sir.
Right, understanding the plea agreement in the range of punishment, how do you plead to assault of a family or household member by impeding breath or circulation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing it?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulated evidence being admitted?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Any stance from, I've got the victim's impact statement. I've reviewed that. And I've signed that. I need to get that back to you for tracking. But is there agreement by the victim? Is she supportive of the plea or non-involved, anything of that nature?
Current compliance, she did request the contact.
Anything further from the defense?
No, sir, except for the judgment issue with the $500 fees.
All right, court will review the evidence at this time. All right, court having reviewed the evidence, finds enough evidence to convict the defendant of the offense. Court will follow the plea agreement. Court hereby defers a finding of guilt, places the defendant on 8 years of community supervision, assesses a $2,500 fine, $290 in court costs. The court also orders that the defendant have no contact with the victim of this offense as a condition of community supervision. And the court dismisses under section 1245, cause number 2026-20, which is a violation of a bond or protective order. Was 2026-20 on my docket, it says it's an assault, causes bodily injury. Misdemeanor A, but is it in fact a violation of bond and protective order? It's bond. All right, Mr. Walsh, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna go, have you go over with Sergeant Martinez, and he's gonna take your fingerprints. When you are released, you'll need to report to the probation department. Have you already spoken with him at all, Mr. Ernst? All right, when you are released, then you're to report to the probation department. And they'll give you additional instructions on how to proceed after that, okay?
Yes, sir.
If you don't, I think the office is open until 7 tonight, is that right?
Yes, but I'm giving an appointment today for the games.
Okay, so she'll give you an appointment card, when you are to show up.
Okay. Yes, sir.
Go ahead and go over there and see Sergeant Martinez.
Thank you very much.
Does that complete your business before the court? All right, I believe that does complete the court's afternoon docket. We are adjourned.